trying cases, sitting on cases, whatever. Bottom line is, how does that tie in with your perception of whether or not we should have work through challenges? Because part of the whole analysis is, prosecutors say all the time, well, it's just my seat of the pants determination that I didn't like that juror. That's just my gut reaction. That's my seat of the pants reaction. What do you think about it from a criminal defense side as it relates to issues, whether or not they're necessary?
Well, I have to agree that from a legal standpoint, you can't say they're necessary, but it would have to be legally protected.
Are they practically necessary then?
I think that, are they practically necessary without licensing semantics? I would say they are, because I think it's preferable in the sense that I think the trial cases involve a certain amount of cooperation, a certain amount of intelligence, as opposed to just some little application of the statute to the facts. My perspective on it is a little bit different maybe than what I've heard so far. Most people I agree look at peremptories as eliminating the order. My viewpoint is more often, because I am a criminal defense lawyer and I don't have the burden of proof, I'm looking to try to get down the road past juror number 13, 14, 15 to get to that 16th juror, because they have some expertise and they have some life experience that I know is critical for proper understanding of my case. Can I give you just
Yes, please.
This is really going to be a non-moving, more of an example. I tried a possession of a firearm in connection with the drug case in the Lafayette division of the Western District. It was critical to someone to understand my case, to understand how rice is formed, how you plant rice, and the stages that rice goes through, to understand why my client would be where he was with the gun. And I know that makes no sense here, but to somebody who raises rice, they would understand, or who at least has some experience in the rice industry. They would understand that when rice...
Why would he want a gun?
Because to shoot hogs. Wild hogs will destroy a rice field if you have hogs in the area when rice goes into what's called milk.
But wait, Tom, let me interrupt you and ask you. I don't want to get into rice farming and all that stuff, but
That's an example.
if the standard is that, again, jury of your peers, et cetera, are we really trying to shoot to get to, in that particular case, rice forming experts, or should that be your duty to explain to a jury how that situation works for purposes of why your client would have been in the fields with the gun? Shouldn't that be your burden to kind of elicit testimony as to how that process works versus someone who knows how rice forming is done for purposes of having a fair jury in that particular situation?
Kim, the issue that I was dealing with, and that I think the peremptories allowed me to address, was to in fact have a jury of my client peers.
Okay, so that's your definition of peers.
To try that case, then sure, I'd be trying the case to somebody who thinks rice comes in a plastic bag and would have no concept of my client's daily existence. It was also very critical in my case to have someone on a jury who had an understanding of the French language. And you may, and I thought, to be honest with you, I thought you could go to Lafayette and at least half the people would speak French. But man, was I wrong.
See by those stereotypes?
Well, wait, let me ask you, then I'll return to Judge Thibodeau. Let me ask you, in that particular case,
If
Tom,
I can just explain, it was because I had a witness that barely spoke English.
I understand that, but let me ask you this question. What ended up being the composition of your jury in that case? How many people spoke or understood French? How many people had an understanding of how this rice forming process works? What ended up being your ultimate jury composition?
I ended up with one man who had grown up
your guy got off?
What happened in my case was the prosecutor saw his case going south and frankly intentionally provoked a mistrial, which resulted in him being dismissed, and that's why.
Well, I think what I've heard from the panel today, all three practitioners. Yes, I'm sorry, please.
Because I don't want to get off on an analogy that doesn't make any sense.
Oh, no, the analogy makes sense. The analogy makes sense.
If I'm going to murder case, and the issue is very critical involving an understanding of an autopsy, and I know that if I exercise peremptories, I'm going to get somebody who's an ER nurse. That's it. That's important to me and to my client. And I'll be more than happy to excuse various jurors, who may be a mechanic, or maybe a draftsman, or maybe a school teacher. If the result of that is that I end up with that superior knowledge that's relevant or that's critically important to a determination of ignorance.
But how would the peremptory challenge enhance that prospect?
Because if I don't have, if I know I can eliminate a given number, 12 people, I don't view it as I'm saying, I don't view it as simply trying to get rid of, doctors, lawyers, and Indian chiefs because of some category that they fit. I mean, obviously, you're going to eliminate the people that you think are negative. I've been at this long enough that I just don't feel that I have whatever the gene is that allows me to see into people's souls, even the word you don't hear. It's a best guess as well. So I'm usually trying to pick neutral jurors, but then I use peremptories when I know I'm not going to be able to get challenges for cause to get further down the road to try to achieve what I think is an extremely beneficial contributor to the.
Well, wait, let me ask all of y'all a question with the exception of Judge Thibodeau.
Good.
The comments I've heard from the practitioners, Tom just said, I don't think had the ability to see into people's souls. Earl talked about the fact of seeing, people see things through a certain prism. Nan talked about the fact of trying to, kind of make sure that there's a fair trial. Doesn't a lot of the language that you guys use as practitioners play into this whole concept of, or in fact, support Judge Thibodeau's position, I guess Justice Marshall's position, that the seat of the pants, these comments about stereotypes, you don't want a lawyer, you don't want a this, doesn't that play into the possibility of using racial stereotypes or ethnic stereotypes or gender stereotypes for purposes of either getting people you don't want on the jury, or in Tom's case, trying to make sure you get somebody you do want on the jury?
Well, I think that, first of all, we need to make it clear that under Batson says, well, you can't use race.
Right.
And then you got JEB that came along and said that you can't use gender.
Right.
And then I believe it's a case that you cite in your paper where you can extend it to that.
That just came out Salazar.
Right. So outside of that, the one thing you can say everything else is fair game. Okay. If you can say, for example, like the lawyer announcement, I don't want lawyers. Or you can say, I don't, in this particular case, I don't want a doctor. Or I get the perfect one, law enforcement. There are times when law enforcement have been in the jury with iron, and you have a criminal case. I would imagine as a criminal defense attorney, I would not want a deputy sheriff on my jury. Okay? And we could talk about what's wrong to make stereotypes and wrong about putting them in the category, but I'm sorry. I don't think that if I was a criminal defense attorney, I would not want someone who was branded bad on my jury for obvious reasons. So I think that because of the limitations, especially in the federal system, that we have to coordinate the juries.
Right, you're very limited in how much
Very
work you can do.
limited. So to some extent, we are level to some, stereotypes, if you will. And so, and whether it's right or wrong, sometimes that's all you have. And so the stereotype is that, well, if you put someone on the jury